Hello and welcome to this episode of Immigration Insight. My name is Jacob Baxter. I'm a lawyer here at Idesi Legal in Wellington, and I have the privilege of discussing today's topic with my boss and principal lawyer, Kamil Lakshman. Welcome, Kamil.
Thank you, Jacob, for that. Welcome too.
Oh, thank you very much. So today we'll be discussing the recent amendment bill to the Immigration Act. Now that's been passed quite quickly in recent weeks. Select Committee finished, from my memory, yesterday. We, of course, were watching the submissions, and that was quite interesting. But today we're going to have a quick look through and try and get more in depth into what this amendment means for the Immigration Act and immigration in general. Would you like to start us off, Kamil?
Yes, well, what was passed today was the Immigration COVID-19 Response Amendment Bill. What I have in my hands is something fresh off the press, and it tells us things that we need to know. We will discuss some of this. There are quite a few things here, but let's start.
Yes, we'll do our best. So this bill contains, from my understanding, a lot of powers that's been given to the Minister of Immigration to make a lot of sweeping decisions or declarations or waivers of certain requirements. So that includes stuff like, and I'm going to consult my notes here, they can impose or vary conditions for whole classes of people for temporary visa applications, for residence visa applications. They can even prevent skilled migrant category expressions of interest from being submitted for a certain length of time. I believe that is 3 months. And that has to be reviewed. But most of these powers, I think it's quite important to say, can only be exercised by the Minister for Immigration. So there's only one power in this bill that can be actually utilised by immigration officers at the border. So and that involves revoking entry permission where people would otherwise have entry permission. So what do you think the implications are of granting the Minister these powers rather than perhaps Immigration New Zealand? What is the main thoughts, do you think, behind
The
that?
Minister already has absolute power. So I don't think it's about his power as such or granting him the power. It's more a case of we are in unprecedented times. COVID-19 has taken the wing out of everybody. And how does anyone deal with it? Now, this Immigration New Zealand is one of those victims. They have been completely unprepared in terms of their workers, the people that actually process the applications. It's quite ironic in the sense that they have spent billions of dollars investing into iGEMS, which is the data capturing website and where you can do online applications and things. Yet the inside workings of Immigration New Zealand, it appears that investment has not taken place. So when COVID hit, and most of us had to work from home, like Idesi Legal had to, we were able to pick up our computers, our telephones, and off everybody went home and started working from home offices. Now, under lockdown, Immigration New Zealand majority of the staff were not able to do it. We are told something like 30% had the capacity for whatever reason. So what that meant was that there were massive amounts of applications, expression of interest. Expression of interest was okay because that was IT based, but applications generally that have just sat there and nobody's processed it. So this is also about a rescue mission for Immigration New Zealand to be given time to catch up. So I think that is a very big reason, but I don't think that's the only reason. The second reason for why this is needed, and this is something that I've been advocating for, which is a holding position, whereby if you have people in the country, their visas are running out, timelines are moving on, work to residence in that period, what do you do with these people? So this is a good measure to have in place, whereby it's a holding position. So let's just give ourselves some time. And by suspending it, it's not going to disadvantage the immigrant, the temporary worker, simply because it will give them there will be a visa granted to them. And it will allow them to stay in New Zealand. The conditions will be lessened. But everything you have to be careful about, because if there are classes being done, you need to make sure, if you're an individual, whether you fit this particular category. If you do, and a blanket rule applies to you, great. But just don't take it for granted.
Don't assume that you are covered.
As we know.
Yes.
That we've had clients that have thought that they were covered in the first period, where that supposedly automatic period was given, where your visa was automatically renewed. But for some it wasn't, because when the clock started and when the clock ended, they didn't meet that timeline.
Yes.
So, yeah, that's the caution. But it's a good thing. It's a good thing.
Yes, of course.
The good sentiments.
Yes, and I think it'll be quite useful for the minister to be able to because I think for the majority of people, the measures that the minister will or may take will apply to them and will hopefully help them. That's the thought behind this.
Yes.
It'll just be very interesting to see. I know one thing we've discussed about internally is about what to do about the labour market test in terms of the essential skills work visa, and whether how that should be dealt with, because there are many Kiwis who are unemployed currently, and the current labour market test says that there has to be no suitably qualified New Zealanders for the role, and it seems to me that there will likely be a lot of suitably qualified New Zealanders who suddenly need roles, and even if a migrant has been working in a business for some time, there could be issues around that.
That's right. So it's difficult, right?
Yes.
It's a really, really difficult situation. And how does one deal with it? I think common sense has to prevail. I think if in this situation, if you say to everybody that labour market test has to be completely satisfied without reasonableness coming into it, no migrant will ever get a job. Because as we know, unemployment is very high. People are losing jobs left, right and centre. So what I've been reading, now did you read that? Where they talked about labour market tests. So what they're saying here is, why am I being asked for updated information about the availability of New Zealanders? The answer they've given in this document is that, the usual INZ needs to balance facilitating businesses getting workforce they need and protecting the employment opportunities of New Zealanders. And they've gone on to say COVID-19 has had significant impacts on job market. Unemployment rates are rising. Assessing applications only on information provided before COVID-19 does not align with the requirement to protect the employment opportunities of New Zealand. Does this mean, so you have to show that they are New Zealanders not available to do the job? Now that's a huge ask. How many people would be able to satisfy that? So then the next thing they have said is, do I have to re-advertise? That's the question. The answer to that is employers aren't required to re-advertise the vacancy. Thank God for that.
Good.
But they may need to provide updated information that there are still no New Zealanders available in this current job market, to the best of their knowledge. Employers may choose to re-advertise as part of providing further evidence. Now, come on, Jacob, what do you think of that?
I think that's putting a lot of discretion in the hands of the case officers who are making these decisions. And I think there's a risk of seeing quite a variety in decisions coming through as to what individual case officers believe is sufficient for the employer to have done in terms of investigating or advertising. I think there could be...
Yes. So I think it will really, really depend on the submissions that you're putting forward. And representation will become very important. And then also assisting the employer in terms of whether the business is genuine and sustainable. What's really interesting is here they are saying, if your business has received a wage subsidy, does this matter? Wow.
As to whether their business is sustainable potentially.
And viable.
Yes.
Naughty.
And to what extent I don't know, how far in the future do they have to look for sustainable, and to what extent do they take into context?
Mind you, they go on to say here, the wage subsidy provides support for business who have experienced a reduction in revenue and doesn't necessarily mean the business won't be sustainable going forward.
Okay.
Employers receiving the wage subsidy can still hire. So that's like a directive and a kind of direction to the case officer. But it depends on the case officer.
Again, like it says, doesn't necessarily mean.
Yes.
That's not completely eliminating the possibility.
Yes. So, oh dear, this is going to be fun and games, isn't it? Very, very vulnerable situation.
Because often...
So the issue will be about sustainability.
Yes.
Same issues as we've always had.
Yes.
Sustainability issues, labour market test issues, and of course the skill match report with work and income.
Mm-hmm.
So I think in the essential skills work area, I really don't know which way it's going to go. So it's all about representation, because it's going to be all dependent on submissions.
Yes.
And how so I thought they'd be more lenient than that, because really when you think about it, if it's going to be labor market tests, it's going to be so difficult to prove it.
Yeah, and I mean, maybe we're just playing devil's advocate. Maybe there will be some internal circulars going around within Immigration New Zealand saying how they should be
Sympathetic.
Approaching these cases, and maybe some guidance as to what extent they should be sympathetic or hardline, because they do, I guess, have the obligation to maintain New Zealand's immigration. But on the flip side, we're seeing the human side of things. They're seeing data.
The funs and games we've seen over the years as to how unreasonable sometimes immigration officers can be. Some are very good, some are very sympathetic, some use common sense, but then others have a very different take on the same set of circumstances. So you can have the same set of circumstances, two different people looking at it with a completely different take. So, this is harsher than I thought it would be. I was actually quite looking forward to the way they were going to deal with this, with COVID-19 and the temporary workers.
We talked a bit initially about this bill, or this change to the Immigration Act, giving the Minister the ability to make these sweeping general waivers or grants of visas, for example. Do you have any thoughts on, I mean, this is all just speculation, any thoughts on what possible statements or waivers or whatever the Minister might make, potentially? We've discussed this a little bit.
Are you talking about suspension of categories?
Yeah, suspension of categories, or any other general powers that the Minister might be making to grant visas to certain kinds of people. Well,
I would have thought that those that had... So the whole point of this piece of legislation was that it was not going to disadvantage the migrant. So, I really think that's a moot point, whether it's going to disadvantage or not. This doesn't look like very advantageous, does it?
We'll have to see. It's. I think the main thing will be seeing how it's implemented.
Yes.
And I think we'll have to keep an eye on how it's being implemented.
Time will tell. We will bring another session.
Updated.
Updated session as we see how the cases are coming along and what's happening, and what kind of responses we are getting from Immigration New Zealand.
Yes.
So stay tuned.
Yes. Well, thank you for tuning in. I think we'll call it there. Everyone stay safe, and we'll keep an eye on what the Minister does from here.
Yes.
It'll be very interesting.
Take care.
Thank you.